Hi, my name is Erica Mitchell, and this is the assignment for tort liability in schools for EDL 850. So tort liability first is defined as some wrongful act or wrongful doing where a person is liable, the person that did the wrongful act is liable for punishment. There are two types of that. There's intentional tort, which is an act or an offense that's committed with intention to harm somebody or put cause damage. And then there's negligence tort, which is accidental or when something happens because a person was neglecting their responsibilities or neglecting something that they should have been doing. Some of the court cases that I researched for this assignment, where in regards to tort in education or tort in schools, 99% of them were with negligence, which is understandable. As I go through these court cases, it makes more sense why this would be more common in schools than intentional tort. So the first one was a case involving a 14-year-old girl. The case is Munn versus Hotchkiss School. And a 14-year-old girl was bitten by a tick when she attended a school trip during the summertime to China. She ended up with a disease that could cause permanent neurological disorders. Her parents sued the school for negligence. That's the tort type. They claim that they did not warn them that their daughter could come in contact with that disease, and they neglected to make sure she was wearing bug spray on the trip, and they should have been checking her and all students for ticks. The parents ended up being awarded $10 million in non-economic damages and 31.5 in, excuse me, 10 million in economic damages and 31.5 in non-economic damages. This is a really interesting case because it's one of those things where you want to say, it just happened. It was an accident. It wasn't intentional. It wasn't the teacher's fault. But in this case, they were under the responsibility of the teachers and staff on the trip, and that puts teachers liable for anything that could happen. If I were to be proactive against this type of case, you just have to cover all your bases. Apparently, you just have to lay it all out there and let parents know that we're going to this country. This is where we could come, what we could come in contact with without having to get into complete specifics, but also just knowing that you're liable and to tread lightly and be careful. I guess treat every student like maybe it was your own child. Would you check your own child for ticks? Would you make sure that your child was wearing bug spray? You could go about it like that. Really interesting case, the first one that I found when doing the research. The next court case that involves tort is Hohem versus Manhattan Beach City School District. A 10-year-old boy was at summer school and left during school session. 4 blocks from the school, he was struck by a motorcycle, and he faced some mental and physical trauma, some like emotional damage as well, some PTSD. Then when his mother came to the hospital and found out what had happened, she, without getting into specifics, also faced physical and emotional trauma. So the mother sued the school district for negligent supervision of her son. And the court ruled that under California law, the school is not responsible for any student or accident that happens off school grounds. They were negligent in the fact that the student left and was not being supervised when he should have been. But this court case kind of was a breakthrough for the negligence in regarding that the way the California law was worded. And it says a school district has a duty to provide reasonable on-campus supervision and to enforce rules necessary for student safety. Using the reasonable on-campus supervision, they they thought that the boy was sneaking out, which he was, that the parent, or excuse me, the teachers should have had eyes on them at all times. But if a student is intentionally sneaking and trying to leave without anybody seeing them, there's a reason that the court ruled in favor of the school district, because that was possible. A good way to prevent this from happening is security doors. Anybody in and out, there's cameras at each entrance and exit, as well as keeping a good attendance record, making sure teachers are diligent about that. The next court case was Perkle versus Oakdale Union School District, and a 13-year-old boy was injured during a free play, which I'm assuming was recess, game of football, tackle football during school hours. He was injured and his spleen ruptured. It was an internal injury that resulted in a hospital visit and a surgery. The father sued for negligence, that's the tort type, that the PE teacher didn't supervise the segregation of the teams, the splitting of the teams. The student that hit his son was significantly larger than him, and the teams size-wise weren't split fairly or evenly, which put him at a higher risk for getting injured. They also claimed that once the student was injured during the game, they moved him to the locker room, got him ice, and kind of just monitored him and didn't give him the immediate medical attention that he needed. The court ruled in favor of the father and awarded the family $8,200. I thought this case was really interesting as well, because it's just, again, one of those things that happens. They were playing football at recess and they got hurt, and he got hurt. I mean, how many times does that happen daily with kids? And we are at risk for being liable for those injuries, and the way we respond to those medical injuries or those accidents that happen at school. A good way would be just consistent monitoring, using your best judgment, your best common sense with how out of hand or how aggressive different games and activities are being played on school grounds, just to cover your bases again. This court case was one of the only ones that I could find that was an intentional tort case. So I'm just fixing how I spelled this. It was Frame versus Camo, and this was about an 8th grade student who was asked to leave. He was being disruptive. A group of students was being disruptive. The teacher was not that class's teacher, but he was another teacher in the building, and he was just covering for another class. Well, the students were being disruptive, and he asked a group of them to leave, which they did, and then another student continued to be disruptive and was asked to leave several times and wouldn't. So the teacher confronted him, and it sounded like it was a face-to-face kind of a standoff type situation. So the teacher grabbed his arm to escort him out, and among that, the student stumbled backwards and hit the blackboard, the chalkboard, and then was still removed from the classroom. The parents sued for assault and battery, but the court ruled that the actions of the teacher were justifiable in order to maintain that orderly learning environment, that orderly classroom. This was surprising to me. I thought immediately that teacher's in trouble. They're liable. They're out the door. You can't put your hands on a student. I thought that was really interesting, the way that the court ruled, because they were able to see that, yeah, you were disrupting the learning environment for yourself and the other students. A good rule of thumb that we have at our school is don't put your hands on a student you may not physically try to move them somewhere. You may not um, forcefully move them somewhere. If they are being unsafe, that's a different situation. If you are having to hold them or hug them to protect them and them from themselves and others, then that's a different story. But forcing them physically to move or to do something, we don't do that. That's just our safe rule. That way, no one's liable. Nothing can be misunderstood or misread, or an accident is less likely to happen. In that case, if something like that were to happen at our school, we do have security cameras in our hallways, not in our classrooms, in our hallways. So if it happened in the hallway, we would be able to see that. If it happened in the classroom, we would definitely have to have some meetings, parent meeting and administrator meeting, some witness statements to protect the teacher and also protect the child, because that's also a really important factor, is making sure that the child wasn't in danger and wasn't in harm's way. The last court case that I researched was Frame versus Camo, and a 14-year-old student was hit with a golf club during a PE lesson by another student, completely accidental. He was knocked unconscious after the hit and ended up dying 2 days later. The parents sued for negligence, that the students were not properly supervised and that they weren't protecting students within a safe, or putting them within a safe proximity of the swinging golf clubs, and that they did not properly educate students on golf safety and being safe when you're playing and being aware of others around you. The court ruled in favor, and they were awarded $50,000 in favor of the parents, and they were awarded $50,000. This was really a sad one to research, because not only do you have a student that has passed away from an accident, but you have a student who was at fault for the accident, and now you have a school who is paying for negligence of a complete accident among a tragedy that has happened. So again, in order to prevent things like this from happening, educate the kids, educate staff members that are there to what to be watching for. Really sad that this is something we have to worry about in education, when we should be mourning the loss of a student and giving support to the other student in this situation. Instead, they were dealing with liability issues regarding this. That was really sad to hear. Some professional ethics that would be really important to have to prevent any sort of tort liability would be just giving your teachers high expectations. Supervise, let them know you have to supervise these kids. If something happens, you're liable. Don't get distracted. Don't take your eyes off of them. That's your duty. That's what you are here for every day. Teaching them how to react to situations and not acting out on anger or frustration or emotion, especially when it comes to a student. Our school has a tap in, tap out system. If we are feeling overwhelmed or feeling frustrated, we shoot a text to a teacher that we have prearranged a relationship with, or our principal, and say, I need to tap out. And if they are available, they'll respond and they'll come and watch your class while you just have a minute to cool off. I think that the no hands-on policy that we also have is a really good rule of thumb, just to protect yourself. You don't know when someone's going to misread a situation. And use caution when talking to others about situations. That's a biggie when you're talking about something that has happened with a student. Be cautious, be aware. Somebody could take that and roll with it. And I think teachers need to present themselves as public figures. You have a life, you have a right to live whatever lifestyle you want, but you are also a public figure and you have a reputation that needs to be upheld. And you're perceived in a certain way. Your choices outside of school are a reflection of you as a professional and of our school as well. So it's important you're aware.